Hello everyone, welcome back to day 15 of Polity Daily Drill. Let's begin. First question. While many states in India have their own high courts, few states share the jurisdiction of a common high court. Which among the following states have a common high court at Guwahati? So we know very well that we have 28 states and 8 UTs, and to serve the needs of these states and UTs, we have in total 25 high courts across the country. So of course it is bound to happen that you will have one high court serving the needs of either multiple states or possibly a state and some UTs. Now in this question, it talks about the states which seek the Guwahati High Court's help in times of resolutions of problems. So we have the answer Assam, Arunachal, Mizoram and Nagaland. These four states are under the common jurisdiction of the High Court of Guwahati. As far as the High Courts of Manipur, which has its own High Court, or Meghalaya, or Tripura are concerned, all these three high courts were established in the year 2013. This was done under a law called the Northeastern Areas Reorganization Amendment Act of the year 2012. So, high courts of Manipur, Meghalaya and Tripura are the more recently built high courts, just like the High Court of Andhra Pradesh built in 2019. The Guwahati High Court is a very old one. It was established in the year 1948. Anyway, so the answer for this question is 1, 2, 5 and 6, which would mean D. Moving on to question number 2. In a recent Supreme Court verdict limiting the provision of coverage of medical termination of pregnancy, that is MTP, to only married women is a violation of which among the following? Article 14, Article 19, Article 21 or Article 18. So recently, that is the year 2022, there was a 3-judge bench which gave its verdict. The case was X versus Principal Secretary, and in this particular judgment the Supreme Court ruled that unmarried women, because so far the definition refer to only married women getting the benefit of abortion, that is termination of pregnancy through medical intervention or a licensed medical practitioner. So the Supreme Court said that unmarried women are also entitled to seek abortions for pregnancies up to 20 to 24 weeks under the MTP rules. In fact, the court said that all women, irrespective of whether they are married or not, had the right to safe as well as legal abortions. This aligns with the principle of equality, the principle of non-discrimination. So, if you treat married and unmarried women differently, then it violates Article 14 of the Indian Constitution, which is the right answer in this case. Moving on to question number 3. In which of the following matters a constitutional amendment is possible only with the ratification of the legislature of not less than 1/2 of the states? Union list in the 7th schedule, procedure in Article 368, administration of areas in the 5th schedule, jurisdiction of high courts for UTs, and reorganization of states. Now, constitutional amendments are done under Article 368 with a special majority. However, if you want to modify what we refer to as the federal features of the Constitution, then we have an additional provision. And what is that? The particular proposal also needs to be ratified. the ratification of at least half of the states is also needed. So in the states, in their state legislatures, the proposal has to be approved by a simple majority, not a special one. And there is no time limit imposed upon the states to approve it. So in that case, if you want to modify any list that is in the 7th schedule, union, state or concurrent, be it transferring subjects or removing subjects, it requires the ratification by half the states. If you want to modify the procedure of Article 368, the same thing is needed. And also if you want to modify provisions of Supreme Court and High Courts, the same thing is required, that is the ratification by half of the states. So 1, 2 and 4. B is the right answer. As far as the administration of the 5th schedule areas is concerned, this is done through a simple majority by law. And as far as the reorganization of states is concerned, this is also done by law. It's clearly mentioned under Article 3 that Parliament may, by law, alter, diminish, increase, decrease areas of the states, modify their names, etc. So, right answer is B. Moving on to question number 4. Which of the following statements with respect to Election Commission of India is incorrect? Please focus. Incorrect. Number 1. The removal of CEC, that is the Chief Election Commissioner, is same as that of Supreme Court judge. This is absolutely correct. Article 324 deals with the provisions of Election Commission of India, a constitutional body, under which clause 5 talks about the removal. So the Chief Election Commissioner is removed in the same manner as the Supreme Court judge. B. The oath of CEC is mentioned in Schedule 3 of the Constitution. Now we know very well that Schedule 3 does contain provisions for oath and affirmation. In fact, we had solved a question on this a couple of days ago, where I had mentioned very clearly that Schedule 3 contains oaths of ministers, oaths of all the legislators, oath for all the candidates, also for the Superior Court, that is the Supreme Court and the High Courts, as well as the CAG. However, Schedule 3 does not comprise of oaths for the Chief Election Commissioner, the other election commissioners, the UPSC members, etc. So B is wrong, which makes it the answer for this question. Let's look at C and D as well. The CEC and other election commissioners receive the same salary as a Supreme Court judge. Absolutely correct. And the ECI decides on matters of splits and mergers of parties is also correct. So right answer is B, the only incorrect statement. And last question for today. With reference to the enactment procedure of the union budget, consider the following statements. The budget is presented by the Union Minister of Finance before a joint sitting of both the houses of the Parliament. This is an incorrect statement. Why is it incorrect? Because the budget is presented in the Lok Sabha, not the Rajya Sabha. Second one, cut motions can be raised only in the Lok Sabha. So while the discussion takes place on the demand for grants, cut motions can be raised, and that is true. Cut motions can be raised only in the Lok Sabha. We have various cut motions like economy cut motion. We also have a token cut motion, and then we have the third one, which is known as disapproval of policy cut motion. So these three cut motions can be raised only in the Lok Sabha. 2 is correct. Third one, the speaker can put demand for grants to vote irrespective of whether they have been discussed or not. This is also correct. We know there's a term for it which is called guillotine. What does guillotine mean? it means the entire debate is cut short and the matter is put to vote. So yes, of course, the speaker can put the demands to vote irrespective of whether they have been discussed by the House or not, which means two statements are correct, 2 and 3. So how many statements are correct? B, only 2. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me, guys. Jai Hind.